harap ng mga baluktot, ako'y nagmamatsyag. Hindi natitinag sa bawat hamon ng mundo. Katotohanan ang aking armas, di ako magpapatalo. Teacher Mark reacts, galit sa kasinungalingan. Sa bawat salita, bumubulusok ang katotohanan. Walang palusot, walang takas sa mali. Ako'y revolusyonaryo sa harap ng mga salbahe. Oh, oh. Bawat reaksyon, mainit at apoy. Sa bawat issue, di ako nagdadalawang isip. Ang bawat...
Yon, welcome back sa Teacher Mark Reaction. Pag-uusapan natin, eto, interim release, no? Yung desisyon sa interim release ni FPRRD, inilabas na ngayong araw na to. So, medyo late tayo dahil nanonood din tayo sa kabila. Dahil ngayon, ginaganap yung year-end party ng C4GG at Batasnatin community. And eto, no? Ano pa ba masasabi natin sa ICC? Kundi ICC bulok. Okay? Saan ka nakakita ng, well, nagkakaroon sila ng interim release, pero bibihira yung nakakakuha ng interim release. Nalagay nyo pa dyan yung interim release kung wala rin naman palang makakakuha. Hindi ba? So ito, panoorin natin.
The appeals to law by relying on hypothetical and non-specific risks to find non-trial chamber erred in law by relying on hypothetical and non-specific risks to find that continued detention is warranted. The appeals chamber recalls that in determining whether the conditions pursuant Article 60.2 of the statute had been met, a chamber must find that detention appears necessary. In this context, the appeals chamber observes that a determination shall be made concerning the possibility and not the inevitability that
Alam mo yun, ang thinking nila, no, doon sa posibilidad lang. Lahat naman ng bagay pwedeng posibleng mangyari. 'Di ba? Not yung hindi yung talagang mangyayari, no? The inability, no? Kundi possibility lahat. Hindi pa nga nangyayari yun, in the future pa lang yun eh. Why would you come up doon sa isang resolution or isang decision based on possibility? Di ba? Posible makatakas si Duterte. Posible din hindi.
Article 58(1)(b of the statute will occur. And that it is the responsibility of the relevant chamber to weigh the evidence before it pursuant to the relevant standard. The appeals chamber notes that in its assessment of risks under Article 58(1)(b of the statute, the pretorial chamber relied on this legal standard. Indeed, the pretorial chamber correctly referred to the standard that the assessment under Article 58(1)(b of the statute concerns the possibility,
Diba?
not the inevitability.
Kasi anong rason? At lagi mong ini-emphasize yung the possibility, not the inability. No, inability. Yun. My goodness.
of a future occurrence. It then analyzed the material before it against this standard. Accordingly, the defense has failed to demonstrate that the pretrial chamber misapprehended the legal standard relevant to the assessment of risks under Article 58(1)(b) of the statute. With regard to the pretrial chamber's assessment and weighing of evidence in assessing risks pursuant Article 58(1)(b), subparagraph 2 of the statute, the appeals chamber notes that the pretrial chamber made reference to 5 documents, including media articles, publications of non-governmental organizations, and a book which, in its view, indicated that Mr. Duterte's inclination to interfere with investigation against him. In relation
Kahit the book. Putik yung basihan nila libro. What the hell is this? Siguro kung if there is a case no filed against FPRRD and those cases were found that FPRRD is guilty, then hindi siya dapat makalabas. But to base your arguments sa isang libro, I don't know if that book is the fact. Okay? Fact ba yung libro? Or what? Diba?
to the first document, a media article, the appeals chamber finds that it was not unreasonable for the pretrial chamber to rely on this document for its finding. Whilst this document does not mention Mr. Duterte himself as being
Hindi naman pala binanggit. Oo, sila na lang nag-assume si Duterte to. Ay ako. Gagi, ang kulit talaga nito. Ay, Zizi. Hindi pwede yan eh. Okay, hindi pwede yan. Lalo sa korte natin. Ako yung nababanggit dyan eh. Oh, ito yung gagamitin ko na ebidensya. Feeling ko ako yung nabanggit dito. Feeling mo lang naman yun eh. You need to prove that ikaw nga yung binabanggit doon. Oh. Ito.
on this document for its finding. Whilst this document does not mention Mr. Duterte himself as being directly involved in briefing individuals, it does not refer to statements of close. It does refer to statements of close associates.
Eh di, ano yung guilt by association? So, sinasabi nila dito, no? Hindi naman si Duterte yung binabanggit dito. Pero, itong mga taong involved dito, no? Kaibigan, kaalyado ni Duterte. Hindi ba guilt by association yun? Porkit kaibigan mo yung mga yun, ibig sabihin, no? Ikaw, parte ka rin nung gumawa. What the hell is that?
Including one where individuals would have been told to remain loyal. In any event, the appeals chamber observes that Mr. Duterte's alleged involvement in briefing individuals is but one of the factors that the pretrial chamber took into account to support its conclusions on Mr. Duterte's inclination to interfere with investigations against him.
Again, 'di ba? Again, you don't even have an evidence, no, that Duterte himself, no, briefed an individual. Kasi nga ang sinasabi nyo, yung dokumento na hawak nyo, no, it does not say that Duterte made it himself. Rather, no, yung mga lalapit kay Duterte yung gumawa. Ano yun?
This inclination to interfere with investigations against him. In relation to the other 4 documents, a book, 2 publications of non-governmental organizations, and a press article, the appeals chamber recalls that there
Yagi. Pwede palang gamitin yung libro as an evidence. Okay? 2 libro. Tapos 1 article. Yun ba yung sumasalamin sa facts? Sa atin kasi sa Pilipinas, no? Hindi pwedeng i-admit yun eh. Kasi nga, no, yung libro sometimes bias doon sa nagsusulat. Kung ano yung biases, no, ng nagsusulat, yun yung lumilitaw doon sa libro na sinusulat niya. Ang pagbabasihan mo, no, 2 libro that was created against him. Article that was created against him. Hindi ba dapat tayo hindi ba dapat pumunta tayo doon sa facts, 'di ba? Doon sa kung ano talaga yung katotohanan. Hindi kasi sabi ng ganito, sabi ng ganyan. Sabi nung isang article na ganito, ganyan. 'Di ba? Anong facts doon? Kaya nga ICC bulok eh. Oh. Yung iba doon mere hearsay. Pero sige pa rin. Which, di ba, nakakapagtaka, di naman submitted as evidence yung book. Exactly. Doon na lang sila kumuha sa libro.
does not exist in the applicable law of the court any impediment to use of newspapers, articles, or other public or open sources for the purposes of assessing the requirement under Article 58(1) of the statute.
Ang sagwa naman nun. So kaya pwede sa kanila pwede sa kanilang gamitin, no? Or pwede silang mag-outsource ng evidence against you dun sa mga nakalathala laban sa'yo. Ngayon, ang tanong dyan, anong nabasa nilang nakalathala against sa'yo? Umpisa pa lang doon sa evidence pa lang, GG ka na dun eh. So, kukunin nilang nakalathala sa'yo, sobrang daming nakalathala against FPRRD. GG ka agad dyan. Oh.
Nor is there any requirement that such material be corroborated. Noting this, the appeals chamber considers that it is possible to discern how the pretrial chamber reached its conclusion on Mr. Duterte's alleged involvement in the threatening and taking of retaliatory.
Again, the key word there is allege. Okay? Allege means no, hindi pa napapatunayan. That is a claim. Diba? So why would you come up with a decision based on a claim? Hindi ba dapat based on the facts? Kasi sa korte natin sa Pilipinas, ganun eh. Kapag magdedesisyon sila based on facts, hindi sa claim. Otherwise, no, we're effed up.
Actions against individuals opposed to him. In any event, the appeals chamber observes that this is only one of the factors that the pretrial chamber took into account to support its conclusion on Mr. Duterte's inclination to interfere with investigations against him, and more generally on the risk of Mr. Duterte obstructing or endangering the investigations or the court proceedings.
Ito pa, obstructing and endangering, no, the court proceeding. If he wants that, sana noon pa. Di ba? Sana noon pa. If he wants to obstruct yung ICC, sana noon pa. Binura niya lahat ng evidence against him. Pero, the mere fact na may mga nakukuha kayong ganyan, isn't it enough evidence that he is not obstructing anything? Di ba?
For these reasons, the appeals chamber considers that the defense has failed to demonstrate an error in the pretrial chamber's assessment and weighing of evidence before it in the context of its consideration of the risk under Article 58(1)(b), subparagraph 2 of the statute.
Based on the book, the articles, no? Ngayon, not because of the evidences, but because of the book and the articles. Yari.
In relation to the pretrial chamber's reliance on the notion of a network of supporters, the appeals chamber recalls that it has considered that it is sufficient for a chamber.
Yo, Mantems, tanong ko lang sa'yo, no? Ito kasi, syempre, ikaw yung ano dito, yung law student, no? Sa Pilipinas ba, our courts ba, no, can use articles, no? Articles and books that were not submitted as evidence, as a reference, no, to come up with a decision to reject, no, yung isang interim release ng isang tao. Na parang, wait, ganun pala yun? Sa atin kasi it's a matter of right eh, yung ano, interim release. Hindi naman interim release yung tawag sa atin eh. Rather, no, piyansa, yun. Yung bail, no? It's a matter of right. Diba? Tapos, it can only be denied. Kasi nga, right nga siya, diba? Pwede lang i-deny yung right mo. Articles and books lang, oo. Doon sila nagbase sa articles and books daw eh. Yung pag-medal ni FPRRD daw sa mga cases, ganun, or pag-usap, no? Pagkausap doon sa mga involved na mga tao doon sa kaso. Reason of why it's not grant because of the articles and because of the right of the persons accused. What the F? Wala na rin naman, wala nang ring right si FPRRD sa kanila, ganun. Diba? No, articles and books are not enough to secure interim release under the Philippine law. Oh, no. Reject. How about reject interim release? Di ba hindi natin ginagamit yun? Basta-basta. Di ba? You need to secure facts and evidence para ma-deny yung interim release mo. Not the articles and books.
To establish that it is possible that a suspect had the necessary assets to abscond, and that there is a risk that a suspect has the financial means to abscond on the basis of concrete evidence. The appeals chamber
Ayan, statutory rules, judicial discretion, actual evidence. Not strong evidence eh.
has also held that the existence of a supportive network and financial means may be relevant to determining whether there is a risk that a person may evade justice or interfere with the investigation.
So dapat, no, dapat kung makukulong ka dito sa ICC, dapat pakita mong mahirap ka. Okay? Kasi kung may pera ka, no, kahit na yung ano lang, yung medyo nakakaangat-angat, no, hindi malabo ka magkaroon ng interim release kasi pati yun i-check nila eh.
And that access to the international contacts could provide the means to enable a suspect to abscond. Whether or not there was evidence that the suspect would actually utilize such contacts. In the Pyongyang decision, in determining whether Mr. Duterte posed a flight risk under Article 58(1)(b), subparagraph 1 of the statute, the pretrial chamber considered that he appears to have the necessary political contacts as well as to benefit from a network of support within the Philippines. The appeals chamber considers that contrary to the defense's argument, the pretrial chamber specifically outlined why it found that there existed a network of supporters in relation to Mr. Duterte.
Hindi pa rin pwede random dude eh. Kahit si VP Sara yung maging presidente, hindi na nila i-let go si FPRRD. Oo. Until ano yan, until bawian siya ng buhay. Kasi nga, ano yan eh, valuable price nila yan eh. Oh, this is the first time an Asian guy, no? Nandyan sa ICC. It's a first time na isang kilalang tao, no, ang nandyan sa ICC. They will never let go of that.
And for which reason this supported its conclusion that the risk under Article 58(1)(b), subparagraph 1 of the statute was established. In the view of the appeals chamber, the manner in which the pretrial chamber undertook this assessment was case.
Pwede. Okay, pwede. Pwede siyang kasuhan. Kasi nga, kung mali nga naman yung yung nangyari kay FPRRD na parang kinidnap lang si FPRRD at tinapon sa hig, pwede siyang sampahan ng kaso at involved siya doon. Chismis talaga. Yes, chismis, tinatanggap.
Specific, as it took into account the specific circumstances of Mr. Duterte, amongst others, his position as former president of the Philippines and his recent re-election as mayor of Davao City in May 2025.
Ano mayor?
It follows that the defense has failed to demonstrate that the pretrial chamber committed an error in assessing and considering Mr. Duterte's network of supporters for the purpose of its examination of the risk under Article 58(1)(b).
Ano daw? Wait.
Of Davao City, Philippines, and his recent re-election as mayor of Davao City in May 2025.
Okay.
It follows that the defense has failed to demonstrate.
Ay, nako. Pati rin pala yung pagkapanalo niya bilang mayor ng Davao City, nagamit din Binoto siya ng marami, di ba? Landslide. So it follows daw, no, na marami pa rin siyang supporters sa Pilipinas. Oo, kasi nag-mayor na naman siya eh. Kaya hindi siya pwedeng makaalis kasi may mga network and connection siya. Ano ba to?
Demonstrate that the pretrial chamber committed an error in assessing and considering Mr. Duterte's network of supporters for the purpose of its examination of the risk under Article 58(1)(b), subparagraph 1 of the statute. Further, under the first ground of appeal, the defense argues that the pretrial chamber's alleged reliance on irrelevant considerations led to errors of law and fact.
Wala nga prima facie evidence. Oo, wala. Base lang sa kung ano ang deem nila na nangyayari. Mantakin mo, ultimo yung pagboto sa kanya, ginamit against sa kanya. Dapat kasi pinanalo niyo yung Nograles eh. O kapag pinanalo niyo yung Nograles, no? Ibig sabihin wala nang support galing sa Pilipinas tong si FPRRD. O baka may chance na pabalikin, yun. Wisit.
Regarding the arguments on the assessment of evidence and in particular the defense's contention that a number of factors relied on by the pretrial chamber were irrelevant, the appeals chamber notes that when assessing the risk under Article 58(1)(b), subparagraph 1 of the statute, the pretrial chamber relied on several factors in support of its finding that such risk existed. It relied on a statement by Mr. Duterte, statements by others, Mr. Duterte's position as a former president of the Philippines and his recent re-election as mayor of Davao City, as well as the matter of the gravity of the alleged crimes and concomitant sentence in case of conviction.
Ano yun? Based on statements ni FPRRD at nung mga malalapit sa kanya. So, kung ano yung mga sinabi nila, no, sa media, that can be used as well. So, dapat manahimik ka, ganon. The hell is this?
The appeals chamber observes that the defense does not explain why, in its view, these factors were irrelevant to the pretrial chamber's assessment. Without more, the defense has failed to substantiate that the pretrial chamber's reasoning and assessment were unreasonable. In the same vein, the defense fails to demonstrate that the pretrial chamber's reliance on Mr. Duterte's re-election as mayor of Davao City in its assessment of the risks under Article 58(1)(b), subparagraph 3 of the statute was unreasonable. Moreover, with regard to the defense's contention that the pretrial chamber selectively cited facts and ignored others in the same items of evidence, the appeals chamber considers that the defense has failed to demonstrate how the fact that the pretrial chamber accorded weight to the statement from Mr. Duterte that it cited should result in the pretrial chamber's ignoring or attaching no weight to other statements. Regarding gravity and concomitant sentences in case of conviction, it is recalled that the appeals chamber has consistently held that these factors are relevant considerations in assessing the risk under Article 58(1)(b), subparagraph 1 of the statute. as these are factors that may increase an incentive of a person to abscond. In the present instance, the gravity of the alleged crimes and the possibility of a lengthy sentence was but one of the factors the pretrial chamber took into account in its assessment of risks under Article 58(1)(b, subparagraph 1 and 2 of the statute. And it looked at the specific allegations against Mr. Duterte. It follows that the defense has failed to demonstrate an error. Regarding the question of whether the pretrial chamber erred in fact by failing to give appropriate weight to relevant facts, specifically Mr. Duterte's health condition and its mitigating effect on the risk factors set out in Article 58(1)(b of the statute as argued by the defense, the appeals chamber recalls that there is no provision in the court's legal texts that specifically provides for the interim or conditional release of a detained person on health grounds.
Nasaan si Ipo? Nandun sa labas.
Nevertheless, the appeals chamber has indicated that the medical condition of a detained person may have an effect on the risks under Article 58(1)(b of the statute, and may be a reason for a pretrial chamber to grant interim release with conditions.
Oh, tama.
The appeals
Pero-
chamber considers that such a determination is necessarily case-specific. Contrary to the defense's assertion, nowhere did the pretrial chamber suggest that it was precluded from assessing the information about Mr. Duterte's health within the context of its assessment under Article 60.2 of the statute. Rather, it noted the reports placed before it and considered that they were unable to affect its finding on risks under Article 58(1)(b of the statute. The defense has failed to show that the pretrial chamber's approach was unreasonable. For these reasons, having rejected the defense's argument under this ground of appeal, the first ground of appeal is rejected.
Reject.
Second ground of appeal. I will now turn to the second ground of appeal. Under this ground, the defense challenges the pretrial chamber's assessment of the proposed conditions of release and state warranties. The defense argues that the pretrial chamber erred in law in failing to address the proposed conditions of release and state warranties.
Bagal magbasa ni ano,
The appeals chamber is of the view that the pretrial chamber did not appear to criticize a lack of detail in the proposed conditions, but rather in the details as how the state which accepted to receive Mr. Duterte would implement the necessary conditions. The pretrial chamber did not consider
Hindi pero nabanggit dito kung anong state, no?
their release with conditions as required, but found that in the circumstances before it, the risks it had identified could not be mitigated by the proposed conditions. Moreover, the appeals chamber is of the view that the pretrial chamber was not obliged, as suggested by the defense, to seek further observations from the concerned state, because it did not envisage the possibility of release given the risks it found Mr. Duterte presents under Article 58(1)(b of the statute. For these reasons, the appeals chamber finds that the defense has failed to identify an error by the pretrial chamber.
Yun nga rin yung lumalabas Mang Temyong eh. Ni-reaffirm lang nila yung mga sinabi nila nung umpisa. Diba? So, that would be a reject to all, no? All basis of or claims, no? Or arguments nila Kaufman.
when addressing the proposed conditions of release and state warranties. In relation to the question of whether the pretrial chamber erred in law by failing to consider if the proposed state warranties could mitigate the risks under Article 58 1b of the statute, the appeals chamber finds that this does not appear from the impugned decision that the pretrial chamber would have required an elimination of risks, as argued by the defense. Instead, the impugned decision specifically states that the pretrial chamber did not consider the suggested conditions to sufficiently mitigate the identified risks. It is also apparent from the factors brought forward by the pretrial chamber when examining the implementation of conditions that it did consider them. Finally, the appeals chamber considers irrelevant to which conditions the prosecutor agreed when discussing potential release of the suspect to the hostage state. What matters are not conditions that may, in principle, be possible in case of a release to a state different to the one proposed by the defense. Rather, what is of consequence for the pretrial chamber's assessment are the conditions and warranties proffered in relation to a release to the state party concerned. For these reasons, the appeals chamber is of the view that the defense failed to substantiate the pretrial chamber's conclusions were unreasonable. Regarding the defense's contention that the pretrial chamber erred in fact and law by taking into account irrelevant considerations in respect to the state warranties, the appeals chamber considers that the pretrial chamber's finding mainly related to the implementation and enforcement of the proposed conditions. It considered the practical implications of ensuring adherence to the proposed proffered conditions in a situation such as the one at hand. It did so against the backdrop of having found that all three risks under Article 58 1b of the statute were established. As such, it was reasonable for the pretrial chamber to examine how, in practice, the suggested conditions would be implemented. The defense has failed to show an error in this assessment. For these reasons, the appeals chamber considers that the defense has failed to show how the pretrial chamber erred in its assessment of the proposed conditions of release and state warranties.
Wala na yan, MJ. Next year, no, mag-i-start na yung trial proper. Okay? Malabo na. Kasi ano na to eh. Nasa appeal na to eh. Itong interim release eh. Oh. Wala ka nang susunod dyan. Okay? Wala ka nang susunod dyan na appeal for interim release.
For the foregoing reasons, the second ground of appeal is rejected. Third ground of appeal. Regarding the third ground of appeal, within which the defense argues that the pretrial chamber erred in not considering humanitarian grounds either as independent consideration or mitigating factor in assessing interim release, the appeals chamber considers that the pretrial chamber did not refuse to address the question of interim release on humanitarian grounds. Rather, it gave the reasons for which, in its view, the humanitarian grounds advanced by the defense were not sufficiently set out in the case at hand. Further, the appeals chamber recalls that the medical condition of a detained person may be a reason for a chamber to grant interim release with conditions, and that the chamber enjoys discretion when deciding on conditional release. The appeals chamber considers that it is not apparent from the pretrial chamber's assessment that it was unreasonable. The pretrial chamber found the existence of risks under Article 58(1)(b) of the statute, which were not mitigated by Mr. Duterte's purported condition, and also could not be mitigated by any condition imposed upon release.
Okay. Wala talaga to, wala.
The pretrial chamber then proceeded to analyze whether humanitarian grounds, as argued by the defense, could justify release on conditions. The appeals chamber thus considers that the pretrial chamber assessed the relevant information before it in light of the arguments made by the defense and reached its conclusion on this basis. It follows that the defense has failed to demonstrate that the pretrial chamber's assessment was unreasonable. Accordingly, the appeals chamber finds that the defense has failed to show that the pretrial chamber erred in its assessment. For these reasons, the third ground of appeal is rejected.
Diba? 1, 2, 3. It was rejected. So, sabi ko naman din, nung umpisa rin, no, na wala talagang, hindi talaga nila pakakawalan yan si FPRRD. Kahit anong gawin natin, no? We can only hope, no? Siyempre, yun lang meron eh. Diba? We can only hope na ibigyan siya ng interim release, pero from 0 to 100, mababa pa sa 50 yung percentage. No? Hindi nga lang 50-50. Mababa pa sa 50 yung percentage, no? Na mabibigyan ng interim release itong si FPRRD. So, dalawa na lang yung pwede mong gawin dyan or antayin dyan. Magkaroon tayo ng trial proper, no? With FPRRD, or yung isa, yung pangit. Oh, hindi na siya makakauwi ng Pilipinas ng alive. Di ba? Well, anyway, no, tapusin na muna natin dyan, guys. Maraming salamat sa panonood. And I'll see you sa next live. Up next natin, eto. Mataas pa nga yung 50% na percentage. Di ba? Up next natin, hindi nakasagot itong si Marcos Lacanilao, no? Doon sa panggigisa sa kanya ni Senator Marcoleta. So, syempre, kailangan magbawi. O, nagparadyo ngayon, di ba? So, yun lamang, guys. This is Teacher Mark out. Bye-bye, guys.
Sa simula't simula pa man, problema'y tila walang hanggan. Mga